A common phrase you may see on an email from a lawyer for a matter involving a debt, or in fact any matter where money is at stake, is "without prejudice." Typically, it'll be bolded and right at the top. This is basically signposting by whoever drafted the email that what comes next is for your eyes only, as the person with the debt against whom the bank launched a proceeding. What comes next is usually an initiation of settlement negotiations with specifics as to how you could repay the debt, including monetary figures and dates. The concept itself is simple, but self-represented litigants often run into two key issues: knowing when something will be protected by the without prejudice rule and the implications of the rule to court proceedings. For the first issue, while usually there will be bolded lettering saying "without prejudice," that itself is not a necessity. Often settlement negotiations are conducted under the presumption that all parties understand the applicability of the without prejudice rule. A genuine attempt to try to settle is taken as invoking the without prejudice rule, and this of course is case-by-case specific. By that same token, saying something is "without prejudice" in bolded letters will not necessarily invoke the without prejudice rule if it's not a genuine attempt to settle, considered in the context of the matter at hand. For example, asking to settle at $1 for a $100,000 debt might not be seen as a genuine attempt to settle, even if the without prejudice wording is applied. For the second issue, what ends up happening frequently is you and the legal representative will engage in a back and forth settlement negotiation. You'll get to court all ready for your hearing, and you may even have included some of the negotiation in your pleadings as evidence as part of your affidavit, and you start off by telling the judge all about the discussions you had, only for the judge to interrupt you and tell you that you cannot be disclosing that information in front of them. At that point, this can make proceedings a lot more unpredictable and could theoretically lead to adjournments to address the deficiencies in the pleadings. So next time you see "without prejudice" in an email or engage in settlement discussions, keep in mind that some communications should not and will not be shared in court, so you can feel at ease giving candid proposals and engaging in a genuine back and forth with regards to settlement. It may be best to reach out to a legal representative to deal with these discussions, as they will be most privy to when the without prejudice rule applies.